guy really loves to hunt small game and really likes to hunt small game during the summer. That's going to be his lease term. You can lease it out to him. When you're doing this, though, it's almost impossible to do this by an oral lease. It's too hard to segregate out the times and get people to remember them. This is another one of these big benefits of having the written contract. You can go in there and specify, this is when you have the right to be here. This is when you have the right to be here. You're prohibited from being on here during this other guy's season. Assignment and subleasing. What are they? Basically, this is when a tenant gives over or assigns or subleases either part or all of the remaining lease term to another person. If there's no agreement to the contrary, the general rule is the tenant can sublease or assign their lease to someone completely different. They have the right to assign those leases. How do you get around that? The answer is you put it in the contract. Almost every written hunting and lease form you see out there will have something on there forbidding the use of, or forbidding the right of assignment and subleasing to other people. This one right here has it in section E, the first one. The lessee agrees not to sublease, license, or otherwise transfer any of the rights or privileges granted by this lease, and only the lessee, members, and his guests shall have the hunting rights of the leased areas. Spells it out right there. Cannot lease it or assign the lease to anybody else. Keeps them from selling it to other people. And there's numerous reasons. If you have a long-term lease with somebody, this person might be moving on. They might not be able to hunt anymore. It'd be very advantageous for this person to turn around and sell the lease that they had. It might be a bargaining chip that you want to say, you know, hey, this clause forbidding subleasing and assignment is in here right now, but if you're willing to pay more for the lease or more for this right, I might be willing to take it out. But there are some caveats. I want to know who you're going to be subleasing or assigning this lease to. You have an agreement and you have a contractual agreement with the person that signed this lease that you entered into in the first place. You may not know anything about the other person that this person went out and found to take over the lease from them. You don't know if they're going to be paying. You don't know how well they'll be able to pay. So that's some things that you might want to be thinking about on the front end. They're much easier to deal with. What happens if one or more of the parties dies during the lease? What do you think happens? You have to take a guess.
Contract ends.
Contract ends, that's one guess. The answer is, it doesn't end. People die. Courts expect it to happen. It's built into the contracts. Generally what happens is, absolutely nothing changes. The estate of the decedent steps in and fulfills the rest of the contract. Whether it's the landlord that passes away or the tenant. If the landlord passes away, then his estate, whoever his heirs are, they have to honor the rest of that contract. Same with the tenant. Most contracts are actually this way too. If you had a contract to deliver timber, you had a contract with a logger that they were going to come in here and log and harvest this timber. Well, before they could come in, you pass away. Is that contract invalid? No. They can still come in there and harvest the timber. They just pay the proceeds to your estate instead of to you directly. There is one exception with that, and that's for unique goods or unique services. And it rarely happens, it never happens with hunting leases. But say you're going to buy a prized racehorse from somebody, and that's the contract. You're going to pay X million dollars for this racehorse. Before you sign the contract, or before the contract can be fully completed, that racehorse dies. You don't just get to go out there and select some other horse and stick it in there and sell it for those X million dollars. That was a unique horse. That was what the contract was about. The same thing about some personal services. The best example of that is Say you're paying a guy to paint a portrait of your family, and this guy is a world-renowned painter. Before the guy gets around to painting your portrait, he passes away. Now, do you really want this guy's 3-year-old kid to step into his place and do a finger painting of your family? The answer is no. You're not going to be getting your money's worth. So there are certain types of contracts and leases that they call it dying with the party. But for the most part, most of them, they don't do it. It stays enforced. That's really important to realize. That way, one or more of the parties don't end up accidentally breaking the contract themselves, thinking, well, that person died, the lease is no longer valid, I can do what I want with the property. You want to think twice before doing that. How do you get out of these leases once you get into them? Well, the first way, and one of the most common ways of getting out of any contract or lease is, a lease or any contract is an agreement between 2 or more people to either do something or buy something. If you get all of the people that are a party of that contract, if we have a hunting lease, me and you, I'm leasing you the land and you're paying to lease it, we can both agree right now, hey, you want to call this lease off? Absolutely, let's end it. In that case, you can end the lease. If there's 3 people involved in the lease, all 3 people need to agree. Hey, you want to end this lease? Yeah, that sounds great. Sure, let's end the lease. That'd be good enough to end it. If all the parties can agree on something, you can either end a lease or you can change a lease during the middle of it. But there's other ways to end leases. First question is, what kind of lease did you have to begin with? Is it a term of years? Is it a periodic tenancy? Those are the 2 main ones. One of the first things I told you was almost every oral lease is going to fall under the periodic tenancy. Almost every written lease is going to fall under the term of years. Because if you're going to take the time to write out a contract, you're going to write out how long that lease is going to last. If you take a look at these, the Mississippi lease, actually, it does state that it is a term of years. But if you flip over to that second lease behind that, and you take a look at that, on the front page, it kind of looks like it's a term of years. The initial term of this lease shall be for a period of 1 year from July 3rd to July 2nd of the next year. You think, well, that's a term of years. However, if you flip the page over to this miscellaneous section, there's a section in there that actually says, well, the lessor can end the contract at any time and return whatever portion of the rent would be owed. That section right there actually turns this lease from a periodic from a term of years into a tenancy at will. Because you just said, hey, one party can end it whenever he wants. That's one of the dangers about using these lease forms without having an attorney go over it. The purpose of these lease forms, both the 2 in this book and the 15 or 20 or so that are located on the CD, is not for you to go out there and craft your own lease. It's for you to look through them and say, what are the provisions in this lease that I really like? What are the provisions that really fit my operation, what I'm wanting to do? You use those provisions, pick them out, and then you take them to an attorney and say, hey, I need a hunting lease. And oh yeah, you're not going to need to spend a lot of time on it because I've already got the things selected that I want you to put in it. And what will happen is that attorney will take those notes that you gave, will turn it over to a paralegal in the office, they'll put it all into one nice neat document, the attorney will review it real quick to make sure there's nothing else that needs to be added, and then they turn it over to you. You've just saved yourself a lot of time and money by looking on the front end, but you still get an attorney to check it out and make sure you're not missing anything. Another problem on the first lease is, okay, you've used the lease. Say you used that first lease and didn't make any changes. What state is this lease geared towards? Mississippi. How many judges in Arkansas do you know that are experts in Mississippi law? Not that many. Judge is probably not going to be very happy if he has to go in there and try to use Mississippi law to apply it to a lease that you entered into in Arkansas. And vice versa for any other state. You need to go through there and make sure, hey, this is going to be handled by the laws of whichever state you're in. If you're going to be requiring insurance, it needs to be, and he says, okay, this insurance is required to go through this carrier. Does that carrier even sell insurance in this state? They may be a carrier that only sells insurance in Mississippi. That's not going to do you a lot of good in Arkansas, is it? So, I mean, you really need to go through these things. You can't just go in there and fill in the blanks with terms. You got to go through it and make sure, okay, this will transfer over. This will be good for what I need. Otherwise, you might be entering into things that you don't really want to. There's a legal doctrine, and it's called the Four Corners Doctrine. And basically what it means is, what the court cares about is what's written from here to here to here to here. What that means is they're not going to take into account things that you may have said before or after you signed the lease. They're not going to take into account when you go in there and say, well, this is what we signed, but we also talked about doing this and this and this. And he didn't do that. The court's going to say, well, is it in the contract? Nope, I don't see it. Therefore, it's not valid. It needs to be in between these four corners or we're not going to look at it. But vice versa, if you just use, and on the other hand though, if you do use one of these lease forms, you're agreeing to everything in this lease form. There may be things in this lease form that you really don't want applied to your lease situation. But if it's in the lease, guess what? It's going to be applied to your lease situation. So you need to go through these leases and make sure, one, all the things that you want is in it, and two, all the things that you don't want are crossed out. Like I said, tenancy at will gets canceled at either time. Term of years, these leases expire at the end of it. If we say, you know, hey, this lease starts January 1st, 2012, lease ends December 31st, 2015, guess what? December 31st, 2015, it ends. Periodic tenancy, these are the ones that are a little bit tricky to cancel. These are those oral leases. If it's a month-to-month lease, you may have to give a month's notice to cancel it. If you're in Arkansas, under the common law, if you got a year lease, you typically got to give 6 months notice. Arkansas modified that. You have to send a certified written letter by mail, or a written letter by certified mail by June 30th of the calendar year before you want to terminate. There are other ways to terminate a lease. What happens when someone breaks their lease or breaches their lease? There are situations when you can go back in and terminate a lease. There's two different types of breaches. One is they breach a covenant, or they breach one of the sections within a lease. So for the first lease, pick one of the sections. Section O, insurance. They chose not to get the insurance. In that case, they broke that covenant O. That's just breaking one of the promises that's found in the lease. Is there a right to terminate? The answer is generally no. If they've just breached one of these covenants within the lease, general answer is you don't have a right to go in there and say, whoop, you broke this covenant of the lease, it must be over now. What typically happens is the court will go back in and will assign damages. Well, you should have paid the insurance. Because you didn't, you're going to have to go back and buy the insurance now, and we might assess a small penalty for it as well. When you're dealing with written leases, the hunting leases aren't too bad. A hunting lease might be 1 page to 20 pages in length. Some of these leases can be hundreds and hundreds of pages in length. If you've got a lease that's 300 pages long, what do you think the odds are of you complying with every single little covenant in that entire lease? None. And courts realize that. So what they'll do is, well, if you broke a small one, you'll just have to make it up. Either we'll force you to go back and fix that problem, or you'll have to pay a little bit of money to set the person back to where they were when it began. If they break one that's really important though, you might be able to get out of it. If they break one that's really important, it might be a breach of contract. It's extremely similar to that breach of a covenant, except they broke something in there that's so important that either you can't fix it or you don't want to fix it and you want the lease to terminate. Can you stop performing on your end of the contract if the other person breaches? The answer is sometimes you can, sometimes you can't. If they breach a covenant, you may still have a duty to keep performing under the contract. If they just breach one small thing. If they make a major breach, you may be able to get out of it. Now the question is, what's a minor breach and what's a major breach? And it's going to depend on the contract. Like I said, typically if you've got a minor problem, they pay damages. If there's a major problem, you get to get out of the contract. Why this usually comes up is you have a problem with the lease, and this, let's say you got a lease that lasts for a couple of years, and either you have a disagreement with the other party, or something else pops up. You're the landlord, you sign a 3-year hunting lease, and you promise not to do any timber activities in that 3 years, and all of a sudden timber prices triple. Well, guess what? You're really going to be wanting to harvest. You may not be wanting to harvest now when prices are rock bottom, but if timber prices triple, you're going to be wanting to find some way either to let him, let you onto the land to harvest, or to kick him off the land. That way you can get in there and harvest. Or, I mean, there's a whole other things that come up. Land closer to your house may become available for rent or to buy, and you as the tenant may want to get out of this lease, take advantage of that other land that just opened up recently. There's a lot of reasons like this that pop up. And what happens, what's human nature is, you're sitting there thinking, I really went out of this lease. I really went out of this lease. And all of a sudden, you say, uh-oh, this guy, he broke this one provision of this lease. That's my cue. I'm getting out of it right now. It's called making a mountain out of a molehill. Maybe what that person did was bad enough to break the entire contract. Maybe what they did was just bad enough to breach a covenant. When you're looking at it from your perspective, all you're thinking is, I really went out of this lease. I really went out of this lease. You may be putting yourself in a position, though, if you go in there and try to kick this guy off, you may be breaking the contract yourself and setting yourself up to a lawsuit. So how do you deal with this? Any guesses on how you deal with it? Put it in writing in the contract. This one lease right here, let's see if I can find that section, actually goes in there and says, lease cancellation. It is mutually agreed that the failure to abide by all the terms and stipulations above by any person under this lease will constitute cause for the forfeiture of all hunting rights, deposits, or leases. They basically say in this contract, hey, if you breach one of these, no matter if it's a small breach or a large breach, we can end the contract. In that case right there, they've taken that risk of going in there and, well, is this a big enough breach that I can end it, or is it a small breach? They took away the guessing game and put it in the contract and took care of it. One of the many benefits of getting these things in writing. The point to it is, you can't just go in there and assume that a contract is ended, because it may just be your wishful thinking. You need to go in there and really dig into it. That's one of the good things about an attorney coming in. You've got this outside third party that's not looking through it in the manner that you are. You've got an interest, you've got a self-interest in it. You want somebody that's got a neutral perspective to take a look at it and say, is this really that big of a breach? Is this bad enough that they should be able to go in there and terminate it? And that's probably one of the biggest issues that pop up under a lot of contracts is when you're dealing with termination. How big of a breach does it have to be before you can get It is simple to take care of though, and that is you put it in the lease itself and you take care of it. And like I said earlier, the best way and the most common way to end a contract or a lease, just get everyone that's a party to agree to end it. That's good enough to end a lease or a contract. If everyone agrees, you can do whatever you want. The important thing is, you got to get everyone to agree. If you've got 5 people in the contract, you need to get all 5 people to come back in and agree that it needs to either be ended or amended. Now, like I said earlier, there's probably 15 to 20 lease forms on the CD that I gave you, as well as the 2 in here. They are a great reference to go out there and look and see, when you're dealing with a lease contract, what are the provisions that are important to you? And they're going to be different. Your land and your situation is unique. There's no other land and no other person out there that is exactly like you. You need to look through these materials and say, and be able to realize, you know, hey, there's certain ones in here that are more important than others. One thing about it, when Carol was talking earlier about the marketing timber, he went and told you, hey, you can put all these other requirements in here that a logger has to do before they can come in and harvest timber off your property. But what was the other thing he said? Your price might go down. You may not be able to lease your property for as much if you go in there and put a lot of stipulations in there. Now, if you've got a place, and like Becky said, everyone's hunting situation and their potential is going to be different. If you've got a place in there with amazing hunting potential, you've got a couple thousand acres of rice up there around Stuttgart, and you can pretty much set your price and you can pretty much make the people do whatever you want, and they'll come in there and they'll rent it. If your hunting's not quite as good though, you may have to be a little bit more flexible. And you have to take a realistic approach to this and look at it. How much of this stuff can I go in there and enforce? What things are the most important to me and what things are less important? What are the things that I might be willing to negotiate away if a lessee comes in here and says, hey, I really don't want to abide by all this stuff? What's the stuff that you'd be willing to cross out and get rid of? What are the things that you feel that are extremely important that need to be in there? Things like, who's going to be carrying the insurance on it? Should there be some kind of indemnity waiver in there? Certain things like that, you need to go in there. Assignment and subleasing. You need to decide there are certain sections that you can't live without and others you can. So use these as for their educational purposes. Try to educate yourself. Pick out the things that are most important to you. And what it'll do, it'll save you a lot of time and money on the back end when you do go to an attorney and say, hey, I want a hunting lease, but we don't need to sit down and talk this all through. I've already got things written out. This is what I want. So, does anyone have any questions on the leases themselves, how to get into them, any of the potential problems, or the like? Okay, with that being said,